Hello, everyone. Welcome to America Some Assembly Required. It is March the 4th, 2025, and today we're going to be talking about a little bit more about our court clerk, and then we're going to move on to our marshal at arms. So today I've got Anna joining us. She's back, feeling well rested, and I'm going to bring Anna on stage, and we're going to get to it. So let's assemble. Hi, Anna. How are you?
Doing good.
Good. You got a full night's rest last night.
For the first time in weeks.
Oh, my goodness. Well, that's a good thing.
Watch out, world.
That's what I think. It's watch out, world, right? So good. So last week we, while you were unavailable, we talked a lot about court clerk, and our court clerk he's a wonder. He is. I always tell everybody the court clerks run the court. I don't care what anybody says, just go ask them, right? and they make sure that all the paperwork, all the workings, everything's done, ready to go. People, are mostly there and organized, and they see to it that all that paperwork is taken care of. It's a paperwork position. Gotta love paperwork for that. So yeah. I thought maybe you might want to speak a little bit on that in your perspective, and then we'll kind of move on.
Well, the court clerks have always been very important to the functioning of the courts. And the courts keep their own records, and their public records. They have to be maintained very honorably and very precisely. And the court clerk system makes sure that that happens. Now, a court can also have a secretary who is doing work with the court and with the clerk, but the responsibility for maintaining the court's records lies with the clerk. And the clerk, therefore, is a position of trust, because both the plaintiffs and the defendants are relying upon the clerk to have exact and accessible record of everything that goes into the case and everything that results from the case, including the transcript or recording of the actual jury process or whatever else is going on in that case. So it's a very important position. It involves a lot of public trust, and anyone who steps forward to be a clerk has to be a person of really good character, have to be very devoted to their task. Pardon me. I'm still suffering from the effects of a bad cold, and so trying to keep my voice going. But anyway, I'm sure that Lisa covered that pretty extensively last week, and she is blessed to have a good court clerk in Ohio. So I'm wishing the same good fortune to every assembly, and be looking for that very special person who has that eye for detail and who is committed to capturing the information and keeping it safe and organized. A lot of people don't realize that the court record is a specific separate record.
Mm-hmm. That's right.
Okay, so if you have something like a complaint, or you have any kind of a testimony, say you're giving information about a possible crime, well, it goes to the sheriff, right? But if you want to create a permanent record, it goes to the court and to the court clerk.
Right. One of the things that I usually explain is that, when it comes to court processes, especially in the criminal aspect, that a complaint can go through the county sheriff and come into the court. It can go through your county coroner or state coroner. And then it also can come through the court clerk as well and enter into the court.
In our system.
In our system, that's correct. And so that kind of eliminates in some ways, the possibility or the worry that you might have a dirty sheriff, a dirty coroner, and you still have, a lawful court clerk that can service whatever that complaint is and see that justice is served as well.
Right. And that's why we have multiplicity of services throughout our government. Mm-hmm. It doesn't hinge on just one office or officer.
It's always checks and balances, right?
Right. And so, for example, people are confused why we have different recording services for land records. We have an international land recording and publishing service, and we have all of the state LROs. And we can also use state-of-state land recording offices where they exist and are cooperative. And it's because we need that diversity of access. And the same thing here, where it doesn't just depend on one office. If it depends on one office or one officer, then it's too easy for that particular position to be targeted and corrupted, and for suddenly no service to be available to the public.
Right, exactly. It's exactly it. And so, as we set up our court systems, we have to be constantly thinking about those types of roles and situations and creating those checks and balances that allow us to make sure that justice is delivered in a way that we've never had it before, right?
Well, not in recent times anyway.
Exactly. So in our system, well, particularly on Ohio's system, the court clerk also kind of oversees. I don't want to call him a gatekeeper because he's not really a gatekeeper in the traditional sense, but he also watches over and makes sure that, for example, to our living court, non-criminal, right, mm-hmm. that people have followed steps of self-governance or arbitration before they're coming into court, or that they just can't complain. They actually have to have a verified claim before they really can, and that's going to help and assist in keeping frivolous claims out of our court. Could you speak to that a little bit?
Well, oftentimes we observe that people are not making the appropriate amount of effort to resolve a problem before they take it to court. Mm-hmm. We've grown up in a society where every problem, let's file a lawsuit. Every little thing, let's file a lawsuit. Let's file a lawsuit. Here's a very staggering statistic. Over 90% of all court cases worldwide are filed here in America. Yes. The rest of the world isn't like this. The rest of the world is not, going to court every time there's some sort of a disagreement. It's only here in this country that we use the courts as our own personal problem sorting service. And by doing that, we give them a great deal more power than we should. Mm-hmm. Because right. We're letting them be the arbiters of our fate and our experience. And we really should be working harder to resolve problems as communities and as individuals before we ever think about going to court.
Right. It's really, we've been indoctrinated into a very litigious nature within mm-hmm. our society. And, we're not, part of our court process is very biblically based in terms of being able to face our accusers, try to make attempts at self-governance and trying to resolve our issue, going through maybe an arbiter that would, listen to the problem and maybe make suggestions. And then if all else fails and everybody wants to just throw the gauntlet down, going into court, but that means our jurors are going to decide for you, right? And that may not turn out so well for the claimant. if they're just being contentious and what I would call rather stupid about their litigiousness, right? So, the first time somebody calls, it has an opinion, right? We all have opinions,
Right.
just like we all have noses and other body parts. And so it is a matter of, it's not, sometimes we don't mean to offend someone. Sometimes we use the long word. Sometimes we call out their behavior. And the first thing we've been indoctrinated is, oh, it's slander. Oh, it's slander, right? And we don't try to listen to, and somebody wants to run into court on slander. I haven't seen too many slander cases in the courts. Usually it's ambulance chasing and neglect of personal responsibility mostly. But
unless you're a member of The View.
Well,
unless you're a member of The View.
Exactly.
They're facing some of the biggest number claims against any organization ever.
And well, they should
defamation of character and slander.
Right. So, but if we, for example, if we tell somebody you're being stupid and oh, you slandered me, well, that maybe you need to be listening, right? It's not a matter that we run straight to the court on. Is my point. It's really about harm or no harm. Have we really done harm? And so, our court clerk has the ability to take a look at that and see whether or not we followed the steps, and to try to resolve it before we take it into our court. He may be he's going to ask for your evidence. He's going to ask for, proof of your claim. He's going to do all of those things, right? Before it goes into court.
Right. Well, and our system of government gives us the ombudsman's office if we have problems with things that the government is doing, right?
Right.
So we have one source of arbitration there that will hopefully stop things from going to court. And then we have all sorts of private arbitration services where you can take a dispute and a third party will review it and give you the pros and cons. Usually these arbitration services are people that have had positions prior to starting their own arbitration service that qualifies them to analyze a case in terms of both the legal and lawful aspects. And they can look at the whole situation as an impartial third party and say, well, there's this, and there's that, and this is the point where it all comes together, and the best thing for you guys to do is, and so using those private arbitration services can really help to diffuse situations and to get to the heart of them and to resolve the problem without going to court, which is great for the court system and great for you, because if you've got a case you think it's really strong, you may not know certain aspects of the law or the way things get organized in a court case. And so going through that arbitration before deciding to go to court is often very useful and insightful. If you do decide to go on from the arbitration process and actually go to court and bring it in as an issue, you'll know what you're facing and you'll be better prepared to answer the court. So hiring a private arbitration service to analyze the case and give you a fair opinion before you actually go to court can often help you to decide whether or not to go to court, number one. And number two, can expose any deficiencies in your argument or your presentation of a case before you go to court.
Okay. All right, great. Anything else on court clerk you want to add before we move on?
Well, the court clerk has a very difficult job. And because of that, I always encourage people to be kind to the court clerk. Be respectful, be kind, be reasonable. And on terms of people being court clerks, there is one little bit of their job that they need to be aware of. If people bring documents to the court, it is traditional and advisable that they bring the court clerk 2 copies of the document that they want to add to their case. And then the court clerk time and date stamps it. And they actually have a little machine that they put the paperwork in, and they date stamp each copy so that the person gets an actual material hard copy with the court clerk's date stamp on it, saying, it arrived here at, 11:03 a.m. on March 3rd, 2025, and then has the court clerk's seal on it. And that way, each person involved, meaning I'm using their definition of person, the claimant and the defendant and the court each gets a date stamped copy that, yes, we did actually receive this on this date. So that's one of the duties of a court clerk that we don't often explicitly say that. And in the modern world, it's sometimes difficult to get a date stamp from a court clerk. You come in with your 2 copies and you ask them to, date stamp receipt of both those copies. They may try to balk. They still do it, but people haven't been doing this enough so that all the court clerks are familiar with having to date stamp documents. Mm-hmm. That they get a copy and the claimant or the defendant gets a copy.
Mm-hmm. Yeah, we've when we've sent people from our litigation in with documents, we always tell them to get it date stamped, timed, and date stamped, and stamped with the court clerk. And we found that when they don't, the consequence of that is a lot of times it's never given to the judge, or it never makes it in their court papers, or conveniently the prosecutor never has exactly a copy of that. So
right. If it's date stamped and the court clerk's office is responsible, then they take very good care of that document and it gets in the right hands in the right timing. Otherwise, their butts are in the ringer.
That's it.
So you want to do this, and the court clerks want to provide this service because this is another way that we make sure that justice is done.
Right. Exactly. All right. Well, Ohio's getting ready to really open up their court completely. We're going to have hopefully our first case coming up here soon, and we're going to have to get a time and date stamp for it. So that'll be another little piece of something we have to do. So
I'm not exactly sure where you can get them, but there are little machines that you can program, and they're almost like a label maker. And you just put the material in the in the little machine, and it date stamps it right there and then.
Well, yeah, you can get them. They're a little expensive, but you can get them. So something that interesting. I've got
a rubber stamp.
Yeah. You can go that way and then write the time underneath it. That's the least expensive way of doing it too. So
it was really funny. I'd forgotten that such things existed, but they've got these little rubber stamps that are on hamster wheels, and you have to turn the hamster wheel to make it go to the right date. That's what I have. I don't have the fancy dancy version. Our court functions with old-fashioned rubber stamps and red ink pads.
Exactly, exactly. Well, I used to use one of those when I was doing human resources for a family company. And whenever I received documents in, I date stamped and initialed it. So, yep, I get that. I get that very much.
So, if the assemblies are just getting started and they're tight for cash and they want to get something done right now, you can still get those. Almost any specialty print shop will have them.
Okay. All right, great. Thank you. Thanks for that good clue. So, anything else before we move on to Marshal at Arms?
Well, I just wanted to draw the attention of the clerks to clerk's praxis, which is an admiralty law thing, but they might want to go over that, not with a caveat that this is not American common law. This is a view of the clerk's office from the view of admiralty and maritime law.
Okay.
And so it's one of the earlier foundational works that was written about the clerk's office in those foreign jurisdictions. But remember, we're going to have to train ourselves up to deal in our own American admiralty law and our own American maritime law to function on those bases too. And, right now we're kind of overwhelmed with having to learn our American common law and the practice of American common law. But further on down the line, we have to be prepared to try cases at admiralty and try cases in maritime jurisdiction as well as land and soil, because we do have American jurisdiction over admiralty and maritime law.
Sure. And I think, Anna, I'm going to suggest it again, is that at some point we need,
I have to mute for just a moment.
All right, go ahead. I was going to say that at some point, I believe there may be a need for some justice training in terms of all of those different functions of our law, in terms of admiralty and American commerce law that will be on our side of that jurisdictional fence. So, it would be nice if there was some kind of an international think tank that was developed to be able to deal for the justices to come together and share their information and their knowledge, and then the different practices of the different areas of law they're going to deal with. So hopefully that'll be something in our future that would be real easy to get done. So maybe another class by Anna for the justices on those things.
Well, I'll tell you what, we are blessed that there was a tome on American admiralty law that was written by Erasmus Benedict, and it's a multi-volume set, and it covers darn near everything you could imagine. But it's a wonderful resource, and we have it.
Oh,
and
that's
so
great.
The hardest part will be getting enough copies of it, or getting it on a database and actually being able to distribute it to everybody, or reprint it, or whatever's necessary. But yes, American admiralty law is wonderful, and it gives us a lot of our defense and a lot of our ability to press against some of the things that have been happening in the British Admiralty courts. So it's a important thing that we need to be aware of and attentive to. Our system requires us to be kind of jack of all trades. Mm-hmm. And ideally, our lawyers know both sides. They know common law and they know maritime and admiralty law. And that's, something that is lacking. It's totally lacking in the current system. Most lawyers do not have that extra training. And so all they know is admiralty and maritime. And they are, as chief, as not Chief Justice, but Justice Neil Gorsuch has said, they are critters of statute. They are creatures of statute. And so that's what they know. And that's all they know. And in a sense, they've been kept ignorant of the actual law, even though they've gone to law school and paid top dollar to learn law. They've only been taught this much of the law. And that keeps them from having the larger perspective necessary to function at common law. And so we have a lot of work before us in terms of tuning up the law schools, as well as getting our own people trained.
Right, exactly. All right, well, great resources. And I wrote those down so that, maybe we can get them into the chat here in a little bit, and make sure everybody's aware. I think there is a PDF out there of the clerk's practice that can be downloaded on a quick search. So that might be helpful.
Yeah, it's actually Praxis, Praxis. It's an old, Latinized word, praxis. But yeah, you can find it. And again, this is about a clerk in an admiralty maritime setting. It's not about a clerk in our common law setting. So people reading it need to be aware of that. But it still gives you an insight into the grounding of what a clerk's office can do and has historically done in admiralty and maritime courts. And that then kind of serves as more of a guideline. So if there's a standard of record keeping for the maritime courts, that gives you somewhere to start for figuring out what kind of a standard you want to employ for keeping records in a common law court, so that the systems are equal, that they're, that if you expect to find this in one kind of court case, you can also find it in other kinds of court cases, and it's kind of uniform across the board.
Right. Okay. All right, great. It's funny. I just did a real quick little search, and there's an audio book, an audio version of it out there, and their picture on the audio version of pirates. So it's
right.
That was rather amusing. So yes.
Well, and it is. It's that's why I'm giving you this caveat. This is about a piratical form of law. It's a seagoing law. But if there is let's look at it in terms of procedure. If you're required to do a date and timestamp in an admiralty court and to give it to the claimant or the defendant, then doing that in the common law court is actually a benefit to the common law court and to its functioning, right? So there are things about the practice that the admiralty courts established that make sense for us, and we should adapt those things that are good and reject those things that are bad. Right?
Sure. Yep, absolutely. All right, well, let's move on. Let's talk about about our Marshal at Arms. So the Marshal at Arms role, I realize that every county is going to have their own Marshal at Arms. We also have a state Marshal at Arms. So as we're bringing up our state court, what do you envision the role of the Marshal at Arms to do in state court?
Well, I think we need to clarify some things.
Okay.
Right now, we have a marshal of arms or at arms in the state assemblies,
Mhm.
but that is a seagoing position. If you look up marshal at arms, you'll see that it's a sea officer. So, what is a sea officer doing in our land assembly courts, in our land assemblies? It's a good question. Well, right now you're borrowing them from the Federation because your land jurisdiction officers, your sergeants of arms or at arms, will not take their office until the assembly is seated. And what this is, you've heard me use the term unlawful and lawful conversion, right?
Mhm.
There's an unlawful conversion and there's a lawful conversion. Well, what happens is a lawful conversion takes place from the seagoing marshal at arms position to the land jurisdiction sergeant at arms position. And what the difference is between sea and land. But because we are coming in from the sea, remember we were trafficked out into the sea jurisdiction, we're coming from the sea back to the land. We have the marshal at arms there for you during the assembly process. And then when you're fully seated, that position will lawfully convert to a sergeant at arms position.
Okay.
Now, when you're looking up marshal at arms, you'll see that it has a much more kind of criminal enforcement element to it than a sergeant at arms. A marshal at arms at sea is a position sort of like a law enforcement officer. Okay,
Mhm.
they're much more attuned to crime and to those sorts of issues than a sergeant at arms. A sergeant at arms is more like a bailiff or a meeting monitor, much more attuned to civilian gatherings, whereas marshal at arms is more attuned to military and martial affairs. Okay, so but that position is being borrowed from the Federation during the assembling process to protect the assemblies.
Mhm.
And then the conversion will happen as soon as you're fully seated. You'll have a sergeant at arms. And I'm explaining that so that people are not surprised and aren't wondering what's going on and why do we have a marshal at arms instead of a sergeant at arms.
Right.
And basically that's why. So the
Okay.
marshal at arms is not a state position, it's a Federation position. And the sergeant at arms is a state position that's permanent. So once you're fully organized and up on your feet and really rolling along, then you'll have a sergeant at arms instead of a marshal at arms. This is a temporary accommodation from the Federation to establish that position. So, number one, you have the benefit of that protection, but also so that you are getting used to the idea of having someone in that slot who's going to be your military liaison for the assembly, and will be working with the Federation, sort of like the coordinators do now. We'll be working with the PKTF on security issues, security of records, security of meetings, um, security of the assembly's um, functions in general will devolve on the sergeant of arms. And right now you've got a marshal at arms. And one of the key things that the sergeant of arms will be doing for you is they'll be the contact person for the peacekeeping task force. They'll be the primary contact person for the peacekeeping task force, which is our Federation organization, which is working to educate and network the entire spectrum of law enforcement and peacekeeping and military forces, so that when something happens, you know, a Chinese missile gets lobbed into uh, Bremerton, Washington, what do? We have to have a rapid response. We have to be able to, really move. So the peacekeeping task force is that communications juncture point that draws in a military response that, flags it and says, and they're the ones that call the local sheriffs and make sure that there's a working communication system. Okay, so your sergeant at arms will be working with the PKTF to keep your state assembly up to date and equipped and ready for that kind of rapid response deployment of multiple jurisdictional forces in the event of a disaster, right? And they will also be responsible for the security of any meetings or events that you have in person. So, for example, the Louisiana Assembly decides to have a community 4th of July picnic. Who's going to be responsible for the security? Well, your Marshal at Arms is going to assess the location, identify any risky things that are there, and deal with it. So you've got to have somebody there that is experienced in security measures and who is competent to either do the job themselves for the scale of the event, or to hire people and bring people in as either as direct hires or as volunteers, depending on the situation, to maintain the security for the event, so that children don't go missing, so that gangs and thugs don't interrupt, or drunks or whatever else that could disrupt. They're there to take care of those sorts of things. And so when I say security, I'm saying it in a broad brush way. That the Sergeant of Arms is, for the assembly, is the state level person who will be the main contact point for that distribution grid of services, and they will do that at the state level. Now, you can also have a sergeant of arms with a county assembly, and then they're doing it within the county, and they're working with the sheriff's department. And the sheriff is another contact point for the PKTF. The militia director is a contact point for the PKTF. So we have multiple contact points, and that's only rational if you think about the sorts of situations that can develop. If you can't reach one, maybe you can reach the other. And so we have multiple contact points in all of the different layers of assemblies, and it's all designed to make sure that you're safe.
And especially in the court situation where we might have a contentious issue, they're there to especially take care of and make sure that the court building is secure, that the courtroom itself is secure, that the justice and the court personnel are protected as their elected officials and things, and that the records and the assets of the court are all intact and secure as well.
Right. And they usually work through a system of bailiffs. And they're basically civilian officers. Oftentimes, police or peacekeepers are there to provide testimony, say, in a case. And because they are parties to the case, they can't be providing security at the court itself. You know, you have to have a third party that's providing the security at the courthouse and in the courtroom to maintain order. And that's why you have the series of court officers known as bailiffs, who are there to maintain order and security for the court as a separate entity. As a, you know, think of it in terms of the of branches of government, right? The judicial system has its own officers known as bailiffs. And they're the ones that kick you out of the courtroom if you're being loud and mouthy. They're the ones that will arrest you if you're held in contempt of court. They're the ones that will secure the funds that are taken in by the court for, say, a fine or a bail bonding. The bail bondsman's office will take in the bond money, and the bailiffs will assist the bondsman in maintaining the safety and security of the bond money. Things of that nature. It's almost like its own little police force within the court system that's there to maintain order and to provide security for the court.
Okay. All right. All right. So with the Marshal at Arms, you know, we've talked about the Assembly Marshal at Arms in terms of providing security for elected officials, correct? In the court system, they're there to protect, for example, the court clerk and the justices, correct?
Yeah, the justices, the clerk, the secretary of the court. I recommend that everybody have a secretary of the court to help the clerk. You know, you basically need someone there who is keeping the tape running and running the transcription service so that the event is being properly recorded. You need somebody there who's going to actually write down how the person spells their name, things like that. And the clerk does that in some cases. Often they wind up functioning as their own secretary. But that's not ideal because the clerk really needs to be watching the ball. The clerk
Right.
needs to be watching what's going on in the courtroom and needs to be taking note of things in addition to the judge, because the judge isn't able to do it all, right?
Right, exactly.
In our courts, our justices are not practicing law. They're acting as referees. But just like if you only have one referee, you may not see all that's going on in a playing field.
Mhm.
Well, the clerk has a role as being that extra set of eyes. And so to an extent, having a secretary, a court secretary, is very helpful to the clerk because the clerk can be paying attention to other aspects. You know, is the evidence secured? You know, when do you bring the evidence into the court? You know, what kind of chain of possession is the evidence in? These are all security type issues that the clerk has to be aware of and working with the bailiffs to maintain. And so when it comes down to the secretarial work, making the recording of the case and all of that sort of thing, it's very, very good to have a secretary.
So is the secretary in some ways the same as the court recorder?
Right. The court recorder or court secretary. You could call, you know, the position has been known in either under either title, but it's a position where someone is responsible for making a record of what's actually said and done during the court case. And that person should be different than the clerk, because the clerk is going to be running security of the court. They're going to be running the records. They're going to have the record of the case that's been developed, the filings and all that stuff. So they've got enough to do without, when the justice is asking if our copy of this document, it's the clerk that needs to be there going, oh, here it is, sir.
Right, exactly. Okay, so that's all right. So Anna, I'm going to take some questions here as we get to the end of this, so that we get some of our questions in. I know we've got quite a few. So one of the questions that I have comes from the Ohio Assembly, and it's actually from our justice, who asked the question about on the last podcast you were on, February the 18th. You told us that the trial by jury verdicts don't have to be unanimous except in capital cases. And he says, this perplexes me, since all I've ever seen and studied so far has led me to believe that trial jury must make a unanimous decision to convict a woman or a man and a grand jury must make a unanimous decision to issue a lawful presentment or indictment. If I recall correctly, in the podcast, you told us that except in capital cases, a majority opinion by a trial jury is acceptable. Could you please explain this in more detail?
Well, I guess I should have said serious cases.
Okay.
Where there's prolonged jail time, or it's a serious crime. It's a felony. It's something that's going to put you in jail for 20 years. It's something important. You do have cases that are trial by jury because the person requested it, that are actually misdemeanors. And the tradition is you don't have to have a unanimous decision on a misdemeanor.
Okay. All right. So for example, sorry.
Well, we're talking about things like murder. You have to have a unanimous decision.
Assault.
Armed robbery. That's going to put a guy away for 20, 30 years. Things of that nature that are felonies, that are very serious, then you have to have a unanimous jury decision. Certainly all capital crimes. Treason is a capital crime. You have to have a unanimous jury decision. Murder is a capital crime. You have to have a unanimous jury decision. Kidnapping is a capital crime. You have to have a unanimous jury decision. But things like...
What about cases that involve property?
Pardon me?
What about cases in which you're going to deprive someone of property?
Well, in those civil cases, is it a felony issue?
Okay.
Like I say, a misdemeanor is a misdemeanor. You get in a bar brawl, you cause $6,000 worth of damage, and you demand a jury trial because you feel that the fight was provoked. Okay? And you are seeking what you see as fairness. The bar owner is there seeking what they see as fairness. The jury hears both sides and says, okay, well, the bar owner should have fixed the bathroom so that both men and women weren't using the same bathroom that night. Whatever crazy circumstance happens. And so, those sorts of things that are below a certain amount of money at issue and a certain amount of damage at issue don't require unanimous decisions. They just require a majority decision.
Okay. Is there a difference between majority and supermajority in that case, or is it just simple majority?
So far as I know, it's always been simple majority. I mean, you might, when you have the court system up and running as it should, you'll have a jury that is called, and it's there to hear the cases of the day. So you may have a jury that's hearing nothing but misdemeanors all day long, but they're different misdemeanors. A misdemeanor, court comes in, bam, bam, bam. This is this little tiny thing, but you have to consider it, make a decision about it, and keep making those decisions all day long in these misdemeanor cases.
Okay.
So that's the way it's supposed to work. But when you get a major trial over something like murder, then those cases can go on for weeks, and they can be producing more evidence for the jury to consider every day. A jury can be impaneled on a treason case for months if it has to go through all of the proofs. A civilian jury we're talking about, not a military jury. The military handles cases like that in a very different way.
I do.
But if we're handling it from the civilian side, those cases can take a long time and take a lot of deliberation because we're functioning in a different system of law and we have different considerations. But for example, treason for us, if we have to consider it, is a big deal, and it is a capital crime. And the person can bring in all the evidence that they can possibly bring in their defense and take as long as it is required to do. And the jury is going to have to be patient and let that be developed because it's their life at stake. Sure. Whereas the military is functioning in terms of persons, not people.
In which you're already guilty before it even starts. So, for the most part.
Well, and for example, there's a couple of very famous cases where on board ship, manslaughter occurs. If it's unintentional, it's tried in a different way than if it's intentional. Somebody clumsily but unintentionally knocks a heavy weight over the side of the ship, and the rope attached to the weight catches another guy and pulls him over into the sea, and he drowns. Okay, that's manslaughter on land. It's an accidental death at sea. The person who was clumsy and who didn't mean to but did it, they're set free. If it's but if there's a knife fight in the galley and the junior cook kills the senior cook, it's equally very abrupt. It's also very cut and dried. A panel of 3 officers decides the fate of the individual on the high seas, and that's it. And they have to be able to do that in summary judgment because of the situation they're in, especially during times of war. Now, most ships have an actual jail, or they have a couple of cells where they can hold prisoners for a certain amount of time. And so they will hold prisoners, but they have a whole different process in terms of military and admiralty and maritime justice. And that's why you see all of these JAG courts are hauling in government employees and military officers. And they can do that under their form of law.
Mhm. That's right. Okay. So I have a question from Lorraine Ham. She needs clarification on court notary. It says Anna's book for jural assemblies clearly had a notary, but in the coordinator call on February 20th, she said no notaries. Huh? And she says, what? So notary publics, our public notaries is not something that we do in our jurisdiction. That's C jurisdiction, correct?
We have public notaries. We do not have notary publics.
Okay. And who commissions those public notaries then? How does that
The
work?
state assembly has to commission the public notaries.
Okay.
They're
And
using
generally,
to do that now.
I'm sorry, they're using what?
They're using the state trust to establish public notaries now. But since the state assemblies are in session and are functioning, and our states are therefore functioning, then it becomes appropriate for the state to establish its own public notaries. See, the difference between our government and their government is ours is public and theirs is private.
Okay.
From our
So
perspective,
that's backwards, isn't it? From what we've always been taught. So,
right. It's a mental change. It's like looking at the world from an opposite side of the fence. From our perspective, their government is private. Their government is corporate. They're running their government as corporations, and those corporations are privately owned.
right.
They're for profit. They're here to provide a service. They're vendors, and we're paying them for their service. So, from our perspective, they are private operations that are held to a contract and are being paid for their services. And they have a right to organize their activities and get the job done, right? But they're private. We're the public government. So when you have an office, public notary, who's responsible for commissioning the public notaries on the land jurisdiction? The state assemblies
Okay.
are.
Okay, well, maybe next week we'll talk a little bit more about the specifics of public notaries, and then be able to spend a little time on them to make sure that everybody's well aware of what they do and what they need, and how to move forward with public notaries. So maybe we can dive into that next week before we move on into the rest of our court personnel.
Yes, well, the public notaries come to us from the Roman system. So that's going to be a little bit of a mind bender too, because they're more associated with the municipal government services than they are with the British territorial government services.
Okay.
So we'll roll through and
Well, we're going to just break shake all those paradigms, aren't we?
yeah,
We're at it. Just blow it all up.
I try to make people think about it in terms of a split rail fence, you know. If you're facing looking across that split rail fence in one direction, you're going to get a whole different view than if you're standing on the other side of that same fence at the same spot and looking in the opposite direction. You're going to get a whole different view, right?
Yes.
So, you know, from our perspective as the employers of all these yahoos, we have a completely different perspective than the employees who are looking back at us. You see, that's where the mirror effect takes place. And you have to keep track of whether you're an employer or an employee throughout this entire process. You have to
Right.
keep track of whether you're public or you're private.
Okay. All right, great. So Lions, you got your answer. So J.K. Fisher says, would you please explain, put that up, vetting? I understand vetting for the offices and the financial people, but do members of the general education or law education committees need to be vetted also?
No. We vet for public offices and positions of trust. And by positions of trust, we mean financial officers.
Right. Exactly. Plain and simple. Let's see here. I always say think of vetting like your job interview, right? That's essentially if they're taking the job. It's not that they're participating as a member or on a committee, but they're actually taking a job on a role on the assembly in an official type of capacity. So,
right.
Okay.
You want to vet your sheriff. You want to vet your treasurer. You want to vet your assembly chairman when they run for office. You want to know if they have a significant criminal history, for example, and what that was and what it rises from. All those sorts of questions are appropriate when you have elected officers.
Correct. Okay, Susan Huss says, is it true that the state marshal at arms can attend any assembly meeting?
Well, it's just as true that anybody can attend any assembly meeting.
Yeah, this is something I find a lot of times on the assemblies is confusing to people. For example, I'll attend a committee meeting and I'm just a committee member, but then the next thing I know is they're going chairman. And I'm like, I'm not acting in a chairman's capacity at this time. I am a committee member, and I'm, committee chairman. What do you think? Is my answer, or I go to militia, and I'm just a militia member.
Right.
I'm not acting in my capacity as assembly chairman.
Right.
So, the marshal at arms or the treasurer or whomever is elected can attend those committee meetings and, be able to, they have a voice just like everybody else does.
We've had a terrible problem with this misunderstanding with our continental marshals. Continental marshals are American nationals. They're ASNs, they're American state nationals like anybody else. And they have this office within the purview of the Federation as continental marshals. But they are also members of their own state assembly.
Right.
So, they come in and they are participating as members of a state assembly. And we've had state assemblies get all in a flap thinking that, oh, it's the feds come down on us. And, trying to assume that these Federation officers are somehow not supposed to be voting in their state affairs. Well, I'm sorry. If that were true, then I couldn't participate in my state assembly. And anybody that was engaged in any kind of duty in a different jurisdiction couldn't participate in their state assembly.
Right.
Now, the reason that federal officers in the pay attention, federal officers are not allowed to participate and vote in our state assembly deliberations is that they're literally working for a foreign government. Federation officers are American government.
Mm-hmm. Right. Well, I always say our superpowers as ASNs and ASCs is the fact that we have one voice and we have one vote, right?
Right.
And when we're acting in that in outside of our offices, for example, always referring to me as speaker within my assembly is not appropriate, because at times I'm just committee member or I'm just assemblyman, just like everybody else.
Right.
And I have one voice and I have one vote. Now, granted, my opinion does tend to weigh a little bit heavier sometimes than some opinions, but it's not the only opinion. It's not the only voice that's out there. And we need to encourage other people to speak up and, exercise their voice, because that's why they're here. That's what brought them here, right? Is that they didn't like being gagged by the district at all. So, we all have, as I've recently explained, we all have a valuable piece of a puzzle. And I tell the story that my father, he was quirky about it. If we had a puzzle out on the table, you had to watch him. You had to practically run security on the puzzle, because he'd come through and he would steal one piece out of that puzzle. And you would have that puzzle almost all done, and you'd be looking all over for that one piece. Did it go under the couch? Is it under the table? Oh, no. It was in my father's pocket, because he had the last piece, right? And each one of us in our assemblies have a piece of the puzzle. And I don't care, what you call that member, whether they've got an office or they don't have an office, they do have a voice.
Well, we have an ongoing struggle with people understanding that the states of the Union function in international jurisdiction. And I'm not sure what we can do to make that more obvious, but we've had a recent flap with the recorders. The state recorders, because they're working within the state, some of them think that they can't function internationally, and they're unaware that their state records are international records. And so we need to clear that up.
Right.
Because, there was a big flap about one of our Federation international recorders giving, they published on the bank system, the International Land Recording and Publishing System. They recorded a declaration and published it and created the record in the bank system, the IORPS, right? And they gave notice to the local state LRO that they had a new member. Well, that's the way it's supposed to work. When somebody declares and they're offshore or are impeded from doing so on land, it's still international. Land and sea are both international jurisdictions. Mm-hmm. So when they publish through the bank system, the bank is supposed to let the state LRO know, hey, another Nebraskan, say, has published on the International Land Recording and Publishing System. Here's their name and address so that you can contact them. Mm-hmm. All right. This is part of that business of having multiple ways of doing things so that one system can't be targeted and undermined, the whole function undermined. So because state recorders work within the confines of the state, they've gotten the idea that they're state level and that they don't have international functions. But the whole point of having a recording system for the state is so that people from outside the state can go on there and look and go, oh, yeah, so-and-so is a state national and they are recorded as such. And,
Well, I think there's a lot of state recorders that are not aware of the fact that there are also international state recorders or international recorders that can record on all 50 states. But our state recorders are really confined to the boundaries of their state. Right. And often I hear the comment of, well, we need a county recorder. And I always say that's, yes, in time you will need county recorders. But right now what we need is to populate our counties so that we can have county governance and a county recorder, because a
Right.
county recorder can only record on the
Within
county.
their county.
Right. And we want to be able to be flexible enough to take care of all of the business on our state. So, I think that's an important, that's a good, analogy in that way. And as long as everybody is doing it so that it's correctly recorded, there shouldn't be any issues.
Right.
And that's, sometimes that's also an issue. We have to make sure that, everybody's playing by the same rules, right? And in terms of that.
Right.
So,
and okay, if we didn't have international functions as states of the Union, why would you have an international business committee or an international business assembly? Obviously, you are in international jurisdiction at times, right?
mhm.
So it really matters whether if you're functioning as a union state and you have your counties organized, you're functioning at a national soil jurisdiction level. If you are functioning as a state of the union, you're functioning in international jurisdiction
Right.
as a whole state.
Okay. I got another question for you. Does the Solicitor General, and I'm assuming that's state Solicitor General, have the responsibility to inform the de facto courts that a change of jurisdiction is required if people have been identified?
Well, in theory, we're finding that the Solicitor General's office has been much neglected, and I guess we could guess that from the way everything's been set up. We have an Inspector General in the office in the Department of Justice. And we have to have a Solicitor General under international law. But you will notice that you don't see Solicitor General of California, Solicitor General of Maine. All you see is one Solicitor General, and they are in the Department of Justice.
Actually, Ohio has a Solicitor General.
Some states do.
We do.
All states should.
Right. Exactly. Okay. So I'm going to put this up. This is a quick answer. J.K. Fisher, yes, but those committee members need to be knowledgeable before they teach? Well, you would hope that committee members joining the committee would have some interest. You would hope that they have a little base knowledge, but not all of them are going to in the beginning. How many of us had knowledge coming into committees, right? We've learned, we've taught each other, but I can't say that the committee has to have somebody who is completely educated or knowledgeable in order to be useful on a committee. What do you think, Anna?
Well, sometimes the primary and first job of a committee is to research what they're supposed to be responsible for.
That's it.
What if you're a part of a committee that is charged with researching and determining the rights of the state regarding vacated railroad easements? Well, maybe you don't know anything about railroad easements, and maybe you don't have a map of those that are vacated. But so you're going to research it. You're going to go to the State Department of Transportation. You're going to find their railroad people. You're going to go to the BLM. You're going to find their railroad people. You're going to find all the experts on easement properties. And you're going to find those who are tracking which of these easements are vacated. You might have to go to the railroad company yourself in order to get the records of those vacated easements. Okay. And this is just out of the blue. This is a topic you never even thought about, right? But as a committee, you're going to have to research that topic. And then you're going to have to bring back your findings to the General Assembly at some point and say, hey, look, we've got 158 vacated railroad easements that are taking up state land and are, causing problems for the landowners in these all the affected counties. Why don't we move to absorb these vacated railroad easements and make them part of the county again, or make them part of the state, so that they go off the railroad ledger and onto the state ledger at least. And that way you maintain and regain control of land that's within your state borders, and within the county borders, within the state borders. All right. So there are things like that that nobody knows anything about. I mean, maybe one person in the entire state might know something about, right? But you're still going to have to research them as a committee, and you're still going to have to come forward and start dealing with some of these kind of housekeeping type things that nobody knows anything about. It's a research position.
Right. Okay. In common law, what punishments follow conviction when addressing capital crimes? I would think that depends on the capital crime.
Well, yes, there are basically, if you're convicted of a capital crime, by definition, it's a death sentence. So, for example, if you are convicted of treason, if you are convicted of murder, in our law, it's very draconian. It's, you take a life, you give a life. It's eye for an eye. It's not the Christian law of, forgiveness. No, common law has been described as vengeful law, and it's not really. But if you have done something that has endangered your entire country, then all of the rest of the people in that country have the right to call you traitor and have the right to invoke treason against you. And so there are certain crimes that once you're convicted, there is no other, our judges can't commute to a life sentence.
Right. That's right. That's right. Okay. So let's see here. It's a little off topic, but I'm going to have you answer it anyhow. Susan Huss, would a non-commissioned volunteer firefighter with no oath to the de facto preclude someone from serving as Marshal at Arms? Sounds like a loaded question.
No, that has no effect on their ability to serve as a Marshal at Arms or a Sergeant at Arms.
Right. As long as they're willing to uphold the public law, there you go. Okay. Wimpy Mueller, Wimpy from the South Africa Assembly. Anna, do you have a clear definition for common law? Natural law, our assembly has been directed towards natural law as a jurisdiction rather than common.
Well, ideally, there is no real difference between the two. There's only been an artificial supposed difference in recent years, because common law embraces natural law. Common law derives from and is a part of natural law. It's the law of the community. It's the law of your traditions and your culture. So, assuming, as it is commonly throughout our human family, murder is a crime.
Mhm.
Theft is a crime. Certain things don't change. You know, attacking a married woman and forcing her to have sex with you is a crime. You know, all these different things are just recognized universally as crimes. All right. So there is a component of natural law in common law. And it's
Right.
just that common law addresses property issues and natural law generally doesn't. It does address some, but it doesn't get down to the level of nitty-gritty and property crimes that common law does. So in my opinion, you're better off with common law than natural law because common law already embraces natural law.
Yeah, and I think, Wimpy, what you have to realize is that, you know, our standard in common law is there harm or is there no harm? I don't think you can get it really any more simple in the decisions as to what kind of harm it is. And, you know, if that's tangible harm, that's financial harm, if that's property harm, you know, those are the issues that you have to sort out within common law. Pretty simple.
Right. And so that's the same in natural law. So it's just kind of verbiage. And the advantage, if you're looking at it in terms of a system of law being a toolkit, which is how I look at it, it's a toolkit for establishing justice, you know, among individuals in a community. All right. So if you're looking at it in terms of a toolkit, common law gives you more tools because it's considered more different versions and um, situations. Natural law is somewhat limited in that regard. You don't have any history. You don't have the toolkit of the common law at hand to draw upon. So you're going to start collecting precedents under natural law, and you're going to wind up with a system of common law. So why not just use the system of common law to begin with?
Oh, great. Okay. Well, Anna, I'm watching time. It is 3:53 our time, so I'm going to have us say goodbye and thank you very much, and we'll be talking. Okay, real
Of
soon.
course. Thank
Thank
you.
you.
Sorry I
You're,
missed last week.
that's all right. I completely understand. So, well, everybody, it's been a full hour and a half, and we will talk to you all next week. Bye-bye.
Take care, dear.